Good evening, everyone. This is day two of Express Certificate course on patents being conducted by DPIIT-IPR Chair, IIT ISM Dhanbad, as part of the certificate course in IPR under the norms put forward by Spriha. I'm delighted to welcome our distinguished speaker, Arunava Maity, sir, partner at Lexicos, a boutique law firm specializing in intellectual property practices. Sir is both a registered Indian patent agent and trademark.
You are on mute.
I am extremely sorry, sir.
And no, it's
Okay.
fine.
Good evening, everyone. This is day two of Express Certificate course on patents being conducted by DPIIT-IPR Chair, IIT ISM Dhanbad, as part of the certificate course in IPR under the norms put forward by Spriha. I'm delighted to welcome our distinguished speaker, Arunava Maity, sir, partner at Lexicos, a boutique law firm specializing in intellectual property practices. Sir is both an registered Indian patent agent and trademark agent with expertise spanning patents, trademarks, and industrial designs. He holds a BTech in computer science and engineering and an MA in software engineering from Jadavpur University, Kolkata, along with a Bachelor of Laws LLB and a postgraduate diploma in IPR with 6 years of dedicated experience in patent drafting, prosecution, and analytics, coupled with 7.5 years in software development at multinational companies. Arunava Mathi brings a unique blend of technical and legal expertise in the field. We are honored to have him with us today, and I'm confident that his insights will be of immense value to all of the participants of this course. Additionally, to mark your attendance, you'll receive and to receive your certificate, we'll be sharing. Uh, I'll request all the participants to please put yourself on mute. Uh, to mark your attendance and to receive a certificate, we'll share a Google form by the end of the session. Please make sure that you fill it. Now, I'd request Arunava sir to continue with this session. Sir, please proceed with your presentation. We are all eager to learn from your expertise. Thank you.
Thank you for and starting off. And so, good afternoon, everyone, and thank you everybody for being here today. And I hope I'm audible, right?
I can't hear clearly. I'm sorry.
Thank you so much. Yeah, so myself Arunava Maity, and it's an absolute honor to be speaking with you session. So today we are going to discuss regarding what are not inventions, okay? And that is described in the
Arno Metiji.
Yeah,
Actually,
sorry.
we can't hear. We can't hear.
Okay, so now this is fine.
Yeah, it's a bit better.
Yes.
Yeah, it's better.
Okay. Now this is fine, sir. Are you
Yeah,
able
yeah,
to hear?
Yes, sir. Yes, sir.
Okay. Sorry. Yeah. Okay. So yes, so we are going to discuss regarding like what is not patentable subject matter, okay, or what are not inventions that has been defined in the Indian Patents Act. And at the very outset, I wish to convey my sincere regards to the distinguished professors, respected staff member, and the bright students of IIT ISM Dhanbad who are present here today. And it's truly an honor to address all of you. And I would like to extend my sincere gratitude to like respected Dean Sir and the Office of DPIIT-IPR Chair of IIT ISM Dhanbad for providing me an opportunity to be a part of these online courses. I hope I can give something so that you can understand like what things you cannot do a patent, and also we can understand like how the courts, like the high courts, specifically high courts, they are apprehending or interpreted this section 3K in real cases. So I'm just sharing my screen to showcase the slides. So I hope my screen is visible.
Yes, we can see.
Okay, great.
Yes,
Thank
sir.
you. Yeah, thank you for the confirmation. So this will be today's agenda. So first of all, like we will discuss like what is patent, and then we shall discuss what cannot be patent. I hope like you all joined the yesterday's session that has been taken by Dr. Pankaj sir, and he has basically provided you regarding the patent and patent procedure, how it like what all those things. So we'll just give a recap on that one. So the first slide would be the what is patent. Then we shall discuss like what cannot be patented. So basically there are two sections in the Indian Patents Act which says about what cannot be patented. Then we shall discuss like the summary of section. Now after that we shall discuss why this section 3 and section 4 exist in the Indian patenting system. Okay, and then there are various case laws relating to these subsections. Now let's proceed. So at first we will understand like what is a patent. So as you all know, so this is basically the exclusive rights granted for a scientific or technological inventions for 20 years. Okay, exclusive right means you are the exclusive owner of any invention if you made that in a scientific or technological inventions, and it is valid for 20 years. What does it mean? That means like if you made any invention, you will be the owner of that invention or of that intellectual property for 20 years. That means if any other person other than you wants to use your invention, they have to take permission from you. And after 20 years, that will go into the public domain. So anybody can use your invention without your permission. Okay. And then it's basically a technical solution to a problem, and that is the patent. So patent should be from the technological or scientific background. Okay, and we have mentioned here like that exclusive rights. So what are the rights that will be assigned? That making, using, offering for sale. That means if you made any invention, you can make. That means you can manufacture, you can use that one, you can offering for sale. That means if you can advertise that one. Okay, you can sell, and even if you can import. And the one most important thing, that this has the territorial right. What does it mean? That means if you file the patent application in India, the validity of patent will lie within India only. So suppose you file the patent application in India and other person from USA, they want to use your patent. So they do not require your permission because you do not have any right in USA. So if you want to get right in USA, you have to file the patent application in US jurisdiction also. So this is the short about what is patent. Now we shall discuss like, yeah. Now we shall discuss.
Sir, sorry to interrupt you in the middle. So are you sharing anything? Because I'm not seeing anything on the screen.
Yes, I'm sharing.
We can see.
Ma'am,
We
I
can
would
see.
request you to please check your internet connectivity because we are able to see everything.
No, I'm just, I'm able to see a screen where that AM is mentioned, like the name of the presenter is mentioned over there. Nothing else.
You can try rejoining, ma'am, because the slides are visible. Maybe the problem is at your end.
Sure, sure. I'll rejoin. Thank you.
Okay, thank you. So now we shall discuss regarding what cannot be patented. Okay, so we found like what is patent and what can be patented. Now we shall discuss regarding what cannot be patented. So there is a specific chapter, that is chapter 2 of the Indian Patents Act 1970, that says about what are the inventions that are not patentable. Please remember, these are specific to Indian jurisdiction also only. Okay, so if you go to the US jurisdiction, in that jurisdiction, these specific subsections or sections are not present. Okay, so in US jurisdiction, there only that is mentioned what can be patented. So outside that one, nothing can be patented. But in our Indian Patents Act, there are two sections which specifically mentions what you cannot make patented, and what other than that you can made the patentable invention. Okay, so first within chapter 2, the first section is section 3, that relates to what are not inventions, and section 4 that relates to inventions relating to the atomic energy are not patentable. That means if you made any invention with respect to atomic energy, you are not eligible to get patent on that one. Moving forward, so yes, so please understand, so this is the no-go zone. So if you made any invention that falls under section 3 and section 4, so you will not get patent. Outside of this section 3 and section 4, you are eligible to get patent, provided you are getting getting that novelty, inventive stat, and industrial applicability conditions. Okay. So now we are moving for the first subsection, that is called section 3A. So there are total of 15 subsections that are present within section 3A. So section 3A to section 3B. So first it comes as section 3A. See here it is written, like if you have invented any frivolous inventions, or if you made any invention that is contrary to natural laws or well-established law, then you are not eligible to get the patent. So what are the examples of frivolous invention? See, if you are claiming like a machine claiming to convert any metal into gold without any scientific basis. So this is basically a frivolous invention, right? So if you are claiming that you are converting any metal into gold without any scientific basis, so that will not going to be considered by the Indian Patent Office. Another thing, these subsections are mentioned and that will be checked by the controller after you file the patent application. Okay, so at the time of filing patent application, there is no check. So once that is published and you put the examination request, the patent office will examine your invention, and if they found, yeah, all are requested to please mute their.
Participants, please mute yourselves. I would request all the participants to kindly mute themselves.
Okay. So what we were discussing, like suppose this is the frivolous invention. So at the time of filing the patent application, the patent office will not going to check. After you requesting them to examine your patent application, they will examine, and if they found your invention lies within the frivolous invention, they will reject your invention. And contrary to natural laws. So for example, like if you are claiming there is a perpetual motion of your machine without requiring any energy input. So that is basically contrary to the natural law or well established law. So if you claim this type of invention, you are not going to get the patent. Now moving to the next subsection, that is section 3B. See, section 3B says about contrary to the public order. That means if your invention is contrary to the public order, if it is contrary to the morality, if it is serious prejudice to the human, animal, and plant life, or to the environment. So how we read this subsection? Serious prejudice to human life, serious prejudice to human health, or serious prejudice to animal life, or serious prejudice to animal health, or serious prejudice to plant life, or serious prejudice to plant health, or if that is serious prejudice to the environment. So if your invention comes within any of these things, so you will not get the patent. So what are the examples? Suppose biological weapons that is harmful to the human or animal life. Okay, so human or animal life. So if that is harmful, whatever weapon you have made that is biological in nature, so you're not going to get the patent. Okay, or suppose you have made an invention that is the gambling or smuggling devices. Okay, so suppose you made a patent that can easily that can like the the master key you have invented, so that can easily able to open all the locks. Okay, so that type of things you will not get a patent, because that is contrary to the public order and morality. Okay, so this from this we can understand that this patent protects innovation, but never at the cost of society, morality, or environment. Okay, so the patent obviously give you the innovative incentive or whatever it may be, but that should not be the cost at the society, morality, or environment, because society, morality, or environment will come at foremost before us, before the patenting system. Now moving to the next subsection. So section 3C. So these says about mere discovery of scientific principle, abstract theory, living and non-living substance. Please remember here this word. Okay, so mere discovery. So what is the difference between discovery and inventions? Discovery means which are already present, but you are just discovering that particular living or non-living substance. So if you are discovering that all living or non-living substance which are there you are not going to patent. You are not going to get the patent on that one. Okay. So an invention means you are applying your mind or you are applying your intellect to make some technical inventions to solve some problem. So that we call invention. So discoveries are not patentable, but inventions, if it provides some technical advantages, you will get the patent. So mere discovery of scientific principle, for example, Einstein theory of relativity. So this is like, suppose the abstract theory. So this is an example of abstract theory with no practical application by itself. So you will not get the patent application. So Einstein will not get the patent application on theory of relativity. Now discovery of new star or planet. So this is naturally existing. So this is a living substance, say non-living substance. Okay. So suppose a discovery of new star, but please remember, you cannot claim the star or planet, but if you invent any device by which you can see that star or planet, that device is a patentable subject matter. But the new star or planet, whatever you have discovered, you cannot claim that one because that is already there. You have discovered only. Okay. And then this naturally occurring DNA or gene sequence. So if that is naturally occurring, you are not going to get the patent. Okay. So suppose here is a short question. Suppose you discover a medicinal plant in the Himalayas. Can you patent the plant itself? No, because you are merely discovering a living substance. But suppose from this medicinal plant, if you invent some extraction procedure or method to get some medicinal component, then you are you are eligible to claim that process, that extraction procedure, because that is unique and that is your invention. You have discovered that plant, so the plant itself, you cannot file the patent for the plant itself. Okay, medicinal plant, but you are eligible to file the extraction procedure whatever you have made, because that is your intellectual output and you are solving some problem to get that extraction. Okay. So now moving to the next subsection, so that is section 3D. So this is one of the most happening subsection. So these are used in the pharmaceutical domain mainly.
Parth Sejpal, sir,
Yes.
I would request you to please mute yourself. Yeah, sir, please continue. Sorry for the
Yeah,
disturbance.
no problem, no problem. Yeah. So section 3D is basically is relating to the new form of a known substance. Okay. So if you are discovering you are discovering new form of known substance which doesn't provide any enhanced efficacy, then you are not going to claim patent. So what does it mean by enhanced efficacy? Enhanced efficacy is basically the therapeutic efficacy. Okay, therapeutic efficacy means, suppose what are the different type of forms? So that is given in the section 3D of the Indian Patents Act. So different type of salts, hydrates. So these are the different forms of a substance. Okay. So suppose there is a already known substance and you have like discovered a new form of that substance, and you are claiming that this new form are doing the same thing whatever the known substance was doing. So you are not going to get the patent because you are not you have not like showcase the enhanced therapeutic efficacy. Okay. And then mere discovery of new property or use of known substance, then also you cannot claim. Okay. So for example, suppose there is a compound. So we all know there is a aspirin. Okay, so there is some there is something that we can find out from this aspirin. Now you are claiming that that is aspirin, which compound is already there, that can be used for hair growth. Okay, so what you are claiming? So new use of a known substance. So the aspirin was already there. So you are claiming the new use, the hair growth part. So you are not going to get the patent. Okay. And then these are the different forms. And the other thing is mere discovery of use of a known process, machine or apparatus, unless it provides a new product or reactant. Okay. So suppose the machine is working in some way and you are just claiming that different use of that machine. so you are not going to get the patent. But if suppose you have made some changes in that machine and you found there is some technical advancement of already available machine, then you are going to get the patent. So the main thing is that you have to showcase the technical advancement. So mere showing the uses, different uses, you are not eligible to get the patent. Okay. Now moving the next section, that is section 3E. See, the mere admixture of aggregation of properties of the components, okay, without the synergistic effect. So what does it mean? Suppose there is an example. See, drug X and drug Y without any improved effect. So for example, suppose you have taken 0.5 gram of drug X, which will cure your fever. Then you are, and also that drug X has some side effect. Okay. Now suppose you are taking 0.5 gram of drug Y also, which can cure your headache, for example. Now you are claiming you are mixing this 0.5 gram of drug X and 0.5 gram of drug Y to cure the headache as well as your fever and having the same side effect. So you are not going to get the patent because that doesn't provide any synergistic effect, right? But if you claim that 0.4 gram of drug X plus 0.6 gram of drug Y, that can cure both of your fever as well as the headache, and that doesn't have any side effect, as you are showing that that doesn't have any side effect, that means you are achieving some synergistic effect. By that way you can claim the patent. But if you are unable to showcase any synergistic effect, you are not going to get the patent. Okay, so there are other examples also that has been provided here. For example, so suppose orange, mango, and apple, you are mixing these. So this is just a mixture. So no new property. So no synergistic effect you are showcasing. So that patent will be rejected under section 3E. So now moving in the next section. So that is the section 3F. So this is relating to the mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way. So what does it mean? It means that suppose there are two different device and each device are working independently by their own way. You are just arranging both these two devices. So this arrangement, if you claim these arrangements, you are not going to patent unless you can showcase some combined technical that combined result providing a technical advancement. For example, here if you are claiming that I have arranging or I have combined this umbrella with a torch, because umbrella has its own characteristics and torch has its own characteristics, right? So if you are combine these two things, so you will not get the patent. But if so, think about the kitchen chimney. Okay, so kitchen chimney is nothing but one fan that is being rotated by one motor, right? But the kitchen chimney is made in such a way that it can suck all the like oil things whenever the cooking is performed, right? So as they are showcasing the technical advancement of the cooking chimney, so cooking chimney is a patentable subject matter. But if you are arranging two or three components that are functioning independently each other, and if you are unable to showcase any technical advancements, you are not going to get the patent. Okay, so unless the integration creates a new technical effect, you are not eligible to get the patent. Now moving to the next subsection, like that is section 3H. So this is basically the method of agriculture or horticulture. Okay. So what does it mean? See here on example we have given. So a new method of growing wheat. Okay. So using a specific irrigation schedule. So this specific irrigation schedule you want to claim. So once you claim this specific irrigation schedule, this is your property. So no other farmer can use that one, right? So that is basically is not allowable. So think, so just like here I have given an example. Just think, so imagine a student of IIT ISM Dhanbad discovers a way to grow plant faster by simply watering it at sunrise. Excited? He files a patent claiming a method of watering plants at sunrise for faster growth. Okay. So now think, so like if he get patent on watering at sunrise, then other person cannot want that. So like that is against the humanity, right? So that's why this section 3H birds patenting of method of agriculture or horticulture. Okay, but please remember that technical devices, tools, or chemical formulation used in agriculture may be patentable. That means the device or chemical formulation that we can file as a patent, but the method of agriculture or horticulture we cannot claim as a patent application. Suppose you made an invention of a device. Okay, so that device, what the device is eligible, by way of camera and image processing technique, the device is able to identify the weeds and automatically kill that weed. So if that type of device you are inventing, though it is from the agriculture domain, you will get, because you are claiming that device, not method, how the method of agriculture or horticulture. Okay, so the method of agriculture or horticulture is not a patentable subject matter, but any device or tool or chemical formulation that can be used to in case of agriculture or horticulture, that is a patentable subject matter. Now we are moving to the next section. So section 3I. So section 3I says like method of medicinal, surgical, curative, prophylactic. So what is a method of medicinal? Medicinal means medicine administration. So administration of medicine. So if you are want to claim that method of medicine administration, no, you are not eligible. Method of surgery, method of preventive actions for curing any disease, method of vaccinations, method of diagnosis of illness, method of treatment, or other treatment of human beings or similar treatment of animal to render them free from diseases. Okay, so why these are not patentable subject matter? Because these basically ensures that universal access to life-saving method. Because suppose one doctor has filed a method of surgery, that means that is his own property. He will get monopoly over that surgery method, right? So the no other doctor cannot use that. So that is basically will like that the patient will die, right? So that's why these type of sections or this type of method is not patentable subject matter. But again, say he see the method of doing something, okay, but if you invent any medical devices which will help to do the surgery, you are eligible to file the patent application and you will get that, because we have filed many patent applications that is related to the medical device. But method of surgery or method of like medicine administration, that are not going to give you the patent in your name. Okay, so the medical devices, instruments, or drug formulations, so that can be patented, but the method of doing these, you are not eligible to get patent. So moving to the next section. So section 3J. Section 3J says about like plants. Either it is whole or any part thereof. Animals. Either it is a whole or any part thereof. Seeds. Varieties or species. So if you claim these things, you will not get patent. Okay. But here is a interesting thing. See, genetically modified microorganism is patentable subject matter, but not the naturally occurring substance. So naturally occurring substance will come under which subsection? We have already discussed. Okay, so naturally occurring substance, occurring microorganism will come under this mere discovery of living substance. So naturally occurring microorganism are not patentable subject matter, but if you genetically modify that microorganism to get some technical advancement, then you are eligible to file that genetically modified microorganism as a patented subject matter. Okay, now we are saying that these plant, animal, seeds, varieties and species. So suppose if you make a new breed of any plant, so you cannot file the patent, but there is another section, that is the Protection of Plant Varieties and Farmer Rights Act 2001. So this act allows you to file that new breed. That means the patent you will not get, but under this like this act, that PPVFR Act, so you are eligible to protect your new breed. Now, moving to the next subsection. So section 3K. So this is again a very happening subsection. Okay. So nowadays, like in each and like most, not each, most of the inventions, you will find this section 3K objection. So that is very important related to like computer science domain, because it says if you are claiming mathematical expression or business method or computer program per se or algorithm, then you will not get the patent. So suppose here one example, the pure mathematical formula like E is equal to MC square, you will not get the patent. But here another thing you have to understand. Here it is mentioned that this mathematical expression is not patentable subject matter. That means you cannot claim the mathematical expression. But suppose if you have invented a new process that requires some mathematical expression to solve, to reach it or to execute that steps, you can write that mathematical expression in the description of your patent application. But you cannot claim that mathematical expression in your patent application, because in patent application, the claim is the heart and soul of your patent application. Whatever you are claiming, that claimed subject matter, the protection on that claimed subject matter, we will only get. Okay. For that reason, you cannot file or you cannot claim the mathematical expression, but you can express or you can mention that mathematical expression in the description of your patent application. Then the business method. The business method, again, the business method you are not eligible to file. For example, method of running an online auction. So this is particularly a business method. So you cannot claim that one, because if you claim that one, the other person cannot run this online auction, right? So that's why you are not eligible to file. Then the computer program per se. Per se means by itself. Okay. So whatever computer program you are writing, for example, in Python or Java or C or C++, whatever computer program you are writing, that computer program itself is not a patentable subject matter. But if you are getting some technique or process out of that computer program per se, sorry, out of that computer program, then you can file that method as a claim subject matter before the Indian Patent Office. Okay. But the computer program per se, that the computer code itself, you are not eligible to get the patent. But if you file the computer program per se before the Copyright Office, you are eligible to get the protection of your computer program per se under copyright. And the last one is the algorithm. So algorithm means algorithm without technical application. Okay. So here, if you see, if you file the algorithm along with the hardware to showcase some technical advancement of with respect to the prior like invention, you are eligible to get. But only defining the algorithm as a claimed subject matter, you are not allowed to get the patent. So please remember, whenever you are doing any invention, please do not claim the mathematical expression or business method or the computer program itself or the algorithm itself. Okay. So here see, if the software plus hardware, as well as you can showcase some technical effect, combination of software and hardware, you're eligible to get that one. But we algorithm without technical application, you are not eligible. You will not get patent. Then another example, see, image processing technique for improving device performance. This is a technique is a like from the computer science domain, but it is providing some device performance. It is improving. That means it is providing some technical advancement. That's why you are eligible to get patent on this image processing technique. Now moving to the next section. So section 3L. So this is basically says about if you made any literary, dramatic, musical or artistic work, or any aesthetic creation such as cinematographic works, television on production. So that will come under Copyright Act. So these are basically arts related matters. So if you made any literary or musical, that will come under Copyright Act, not the Patent Act. So that's why the Patent Act has specifically excluded this subject matter for being patented. Now moving to the next subsection, so section 3M. So it says about the mere scheme, mental act, or method of playing games. So these are not patentable subject matter. For example, method of teaching, training, or instruction, you will not get the patent. For example, like if you want to claim the method of playing chess, so that is basically mental act. So you are not going to get the patent on method of playing chess. Okay. Similarly, like if you claim any mere scheme, mental act, or method of playing games, so we are not like playing games means cards. So if you want to claim any method of playing cards, so you are not going to get patent on that one. Now moving to the next section, section 3N. So this is basically the presentation of information. So that how you are presenting the data or information without having any technical contribution, that is not a patentable subject matter. Suppose you are graphically representing the stock price, you are not going to get the patent on that one. And the next subsection is topography of integrated circuit. So the layout design of integrated circuit. So that is not a patentable subject matter. Again, the pattern. So what does it mean? Like the pattern of transistors and connection inside a microchip, that is not a patent. But if you made any topography, you are allowed to file that topography under this act. So what is the act? Semiconductor Integrated Circuits Layout Design Act 2000. So the topography of integrated circuit can be protected under the Semiconductor Integrated Circuit Layout Design Act, but not under the Patent Act. Now moving to the next subsection. So this is the last subsection. So this is section 3P. So this relates to traditional knowledge. So if any ancient practices you want to claim, so you are not getting it. Okay. But the novel formulation with unexpected technical effect, you are eligible. So you have, suppose you are mixing 2 or 3 composition and you are showcasing that you are getting some technical effect out of that formulation. Yes, you are eligible to get the patent application. You are get the patent on that one. Okay. So this is a quick recap of whatever we have just discussed. So see section 3A to 3P. So this is nothing but whatever we have just discussed. I have just mentioned. So moving to the next slide. So the next section is section 4. Okay. So section 4 says about no patent shall be granted in respect of an invention relating to atomic energy. That means if you made any invention out of atomic energy, no, you are not going to get that one. Okay. So section 4 gives specific to the atomic energy. So any invention related to atomic energy, that is 100% will be rejected by the Indian Patent Office. So that is a quick quiz. So suppose there is one question, like suppose which of the following is not excluded. So section 3 basically excludes many things, correct? So which of the following is not excluded under section 3 of the Indian Patents Act? So the first one is the perpetual motion of machine that violates natural law. So it is there, correct? Now the second is the new form of known drug without improved efficacy. So within which subsection it is there? It is within section 3D. Now, so that is also excluded. The section C, that C says a process of manufacturing a new type of solar cell. So that is patentable. So that is not excluded. So you are basically providing a process for manufacturing a new type of solar cell. So this is the technical advancement you are showcasing by way of claiming a process for manufacturing a new type of solar cell. And last, the computer program per se. It is also a non-patentable subject matter because it will come under section 3K. So there is another question. So this is just for your understanding only. So suppose which type of software related invention can be patented in India? So can be patented. Okay. So the trading algorithm for stock prediction? No. So if you only claim the algorithm, you will not get the patent because it is basically a type of business method. Second, the business method executed in the mobile app, you are not going to get the patent. A software per se without technical contribution. Software per se means the computer program per se. Again, you are not going to patent, but an AI-based image recognition system for improving camera hardware. Yes, you are going to get the patent because you are improving something. Okay, so you are achieving some technical advancement over the prior art documents. So now we understand like why this section 3 and section 4 are exists. See, if the patents are for invention, why we exclude anything at all? So this is the balancing act, so why this innovation? So there is in one side, the innovation provide incentives to the inventor. Okay, so if any inventor make any invention, they file the patent, they can commercialize that one. So they will get the incentive. On the other hand, once you get the incentive, the public at large, they are not able to use that one. Correct? So the monopoly will be with the inventor only. So the public interest will be hampered. So there is a ethical concern. So that's why the section 3 and section 4, that is basically a balancing between the innovation incentive and the public interest. That means there are various things what you can file the patent, for that you can incentivize. But there are something which is against the public interest, you are not allowed to get the patent on that. And those things are particularly mentioned in section 3 and section 4. That means the patents encourage innovation, but not everything should be monopolized. Yes, like, do you have any questions? I heard some voice basically. Okay, so all good. I think we can move forward. So okay, now we are going to discuss regarding various case laws in each and every subsection. So we'll discuss very shortly to understand like what are the things. So what does it mean by case law? Case law means suppose you have filed on patent application and that patent application has been rejected by the Indian Patent Office, citing some of section 3 or section 4. Now you are moving to the court challenging the decision taken by the Indian Patent Office, that the output of the court decision we call it as a case law. So this is basically I am giving an example of section 3B. So what this section 3B says about? It is basically if any invention contrary to the public order, so that will come under section 3B. So this case law is related to the ITC Limited versus Controller of Patent, and this has happened in Calcutta High Court 2025, a few days earlier. So ITC Limited, basically they have filed on patent application, and the patent application name is a device and method for generating and delivery of a nicotine aerosol to a user. Okay, and the patent office has rejected this patent application, citing section 3B and serious prejudice to the human health. But the Calcutta High Court set aside the controller's order. That means the Calcutta High Court has rejected the whatever controller has decided. Okay, why? Because they have given some obviously reasons. That's why they have set aside the controller decision. The case was remanded for the fresh examination because the court has clarified that the 3B must be applied with careful analysis of the intended or primary use of invention. Suppose the patent office saw there is a nicotine word in the patent application, so refuse that one. But this patent application is not at all with the respect of nicotine. This is basically some chemical things which are happening between the nicotine and any other chemical matter to generate the aerosol. Okay, so that's why uh, the patent office has said that uh, this intended and primary use of the invention is not for harming. Okay, so it is not prejudice to the human health. So this is not presuming the harm merely based on the category. So if that is the nicotine device and you are presuming that that will harm to the human being, so that is not the case. So it should not be rejected under section 3B. And the Kolkata High Court has remanded for the fresh examination. That means the patent and trademark office has to again re-examine the patent application, and they have to give their decision based on the re-examination. So what is the key takeaway? Key takeaway is section 3B objection need evidence. So need evidence. So no blanket objections should be there. Okay, and the technical merits matter. So if you showcase the technical matter, technical merits out of your patent invention, so you are going to get the patent on your invention. So now we are moving to the next case laws, that is under section 3C. So this is basically for the mere discovery of scientific principle or abstract theory of discovery of living or non-living substance. So we like read this one, right? What section 3C about? So this case law is relating to the Diamond Star Global SD and BHD. This is basically the private limited. So this is the company from Malaysia, I think. So that's why they write like this. Okay. So Diamond Star Global SD and BHD versus Joint Controller of Patent. So this case law has been decided by the Delhi High Court. So what this case law relating? So this is the patent application and the file and this is related to a personal care product formulation containing wood vinegar. Okay, so this is the naturally occurring substance. That's why the patent office has rejected. But the Delhi office has quashed the rejection. Okay, Delhi office says no, by simply seeing the wood vinegar, you cannot reject, because what they have done, since the claim involves selection of a particular plant species, identification of concentration range, removal of undesirable compound, and process of preparation which provides a technical purpose. That means these are the technical input of the inventor, and it's not the mere wood vinegar which is a mere discovery. As the inventor or the applicant has the technical input and they are showcasing some technical advancements, that antimicrobial with discrimination. So as they have some technical input and they are getting some technical advancement, so this is the patentable subject matter. So that cannot be rejected under section 3C. So what is the takeaway? So section 3C is not for blanket ban for natural substance. Okay, so if you are using the natural substance to get something or you are doing some technical modification out of this natural substance, yes, you are eligible to get the patent, and that will not be rejected under section 3C. Now moving to the next subsection. So section 3D. So what D says, mere discovery of new form of known substance or mere use. Okay. So this, as I said, so these sections are mostly related to the pharmaceutical domain. So this case law is Taiyo Pharmaceutical versus Controller of Patent, and that has even been given by the Delhi High Court. So yeah, so this is regarding the yes.
Sorry, sir. Please continue.
Yes. So, yes. So this is regarding what is the issue? So this patent is filed for an anti-cancer compound, and this is rejected under section 3D. What Indian Patent Office said? Indian Patent Office said no proof of enhanced efficacy. That means there is no therapeutic efficacy has been claimed by the applicant, and also the IPO provided unclear prior art comparison. Okay, so IPO is saying that mere use of known substance, but what is the known substance? They have not provided. So the Delhi High Court has have thoroughly examined the whole procedure, and the rejection, whatever that has been made by the patent office, that has been set aside. That means the Delhi High Court says that whatever rejection that has been done by the controller, that is not correct. Okay, so they have set aside the rejection made by the patent office. And why? Because the court says IPO failed to specify the known substance used for comparison. So they are unable to show what is the known substance, and they are showing they are rejected the invention by showing that this is the new form of known substance. So that is a vague reason, right? For that reason, the rejection has been set aside by the controller of the rejection has been set aside by the Delhi High Court. So what is the key takeaway? So section 3D objection must be specific and evidence based. Okay. So whenever the patent office are going to reject your application based on section 3D, they have to be specifically mention which known substance they are referring to. And obviously they have to provide some evidence based on that one, okay, before rejecting your patent application. Now moving to the next subsection, so section 3E. So what does it mean by section 3E? So mere admixture of aggregation of properties of component. Okay, so this is basically Novozymes versus assistant controller of patents. Here, this has been like done by the Madras High Court. So what is the issue? So this is the patent application was filed for the thermostable cited variance rejected under. There are two subsections that has been cited while rejecting the patent application. One is the section 3D and another is the section 3E. So in section 3E, the patent office said this is the mere admixture and there is no synergistic effect shown. Okay, but the Madras High Court has upheld the rejection. That means the Madras High Court agree the rejection made by the controller of the patent application, because the Madras High Court said there is no evidence of synergy in composition has been shown by the applicant. Okay, so the rejection is valid. So if you are unable to showcase, like enhanced efficacy uh, by admixturing of different components, you are not eligible to get the patent application. Now moving to the next subsection. So this is relating to the 3F. So this is like the mere arrangement or rearrangement or duplication. Okay, so this is basically between the K. Manivanan and the chairman, and this is again given by the Madras High Court. So this patent is related to a paddy threshing machine challenged by the petitioner, and the patent was rejected under section 3F. Why? Because the controller of patent said this is the mere arrangement of known devices, and there is no inventive step. Okay, but the Madras High Court upheld the patent. That means whatever rejection made by the controller, they have rejected that refusal order, because they said a small design modification led to real technical advancement. So if you showcase a small design modification which are providing some technical advancement, you are going to get the patent one. Even if that is rejected by the patent office, you are able to appear before the High Court and challenge the decision taken by the controller of patent. So what is the key takeaway? The takeaway is section 3F excludes only trivial rearrangement or duplication. If you showcase some technical improvement based on even a minor change, you are eligible to get the patent application. So just understand, you have to showcase some technical improvement or technical advancement. So whatever you are doing, so if you showcase that some technical advancement or some technical improvement you are achieving out of this arrangement or rearrangement, you are done, you are able to get the patent application. Okay, so the focus is on the technical advancement, no, not the superficial changes. Okay, so the changes may be very small, but if you are achieving the technical advancement, you are able to get the patent. Now moving to the next subsection, uh, section 3I. So this is basically method of medicinal, surgical, curative and all those things, right? So this is Athrogen GmbH versus the controller of controller general of patent. So this is this Athrogen's patent for gold nanoparticle based process to enrich blood serum with protein. So see the gold nanoparticle based process. So these process they are claiming not to enrich blood serum, but as the patent office they see that these are enriching some blood serum, they have rejected this patent application under section 3I. The applicant moved before the Delhi High Court and the rejection has been overturned by the Delhi High Court, because whatever the Delhi High Court said, the Delhi High Court said that the invention was manufacturing process, not a direct treatment method, because the manufacturing of gold nanoparticle based process. Okay, so this will not come under section 3I. So section 3I covers only treatment method not related to production process. So scope of the claim is critical in deciding patentability. That means the claim of your patent application is very much very much crucial, like how you are framing the claims. So if you frame the claim in such a way that you are claiming the manufacturing process, you are eligible to get the patent. But if you frame the claim in such a way that relates to method of some surgical or treatment, then you will not get the patent. Okay, so the way you are formulating the claim subject matter, that is the most important thing. Okay, so by that way we can overcome the section 3 objections and you will eligible to get the patent. So that's why the patent drafting is very important, and specifically how you are drafting the claim, because the claim subject matter is the most important thing, and that is the heart and soul of your patent application. Now moving to the next subsection. uh, Yes, so this is regarding the section 3K, as I said. So this is one of the most happening subsection. So this is related to the computer program per se, or algorithm, or business method, or mathematical expression. So see, previously, basically, this section 3K was very rigid. What does it mean? That means, like, even if you simply writing something in your claim subject matter, a process of a computer implemented or something like that, that were immediately rejected by the Indian Patent Office. But in today's world, each and everything requires the computer program per se, right? So that's why now the patent office are little bit of lenient. Okay, so because that's why they have provided some like CRI guidelines, computer related invention guidelines. In that guidelines, they have said, like, if you claim your computer related invention in such manner, you are eligible to get the patent application. You are eligible to get the patent. Okay, so this patent application is related to the BlackBerry Limited versus Controller General of Patent, and that has been given by the Delhi High Court. So what is the issue? The issue is a patent for media file optimization system that was rejected by the Indian Patent Office under Section 3K. IPO Indian Patent Office argued that it was a computer program per se lacking technical contribution, and BlackBerry Limited, the applicant, they are not happy with the decision what IPO has taken. They have moved to the Delhi High Court challenging the decision that has been taken by the Controller General of Patent. Now, the Delhi High Court, the judge of Delhi High Court, they have reviewed the whole patent specification, the claim subject matter, as well as the rejection order given by the controller of patent. After reviewing all the things, they have the rejection has been overturned. That means whatever rejection that has been made by the patent office, that has been set aside by the judge of the Delhi High Court. Okay, and why they have overturned that one? They said this patent application showed technical effect. Why? Because this is relating to improve device performance via memory optimization. Pure algorithm claims remained rejected. So if you are only claiming the algorithm without having any hardware, and if you are unable to showcase the technical advancement, you are not going to the patent. Okay, so what are the key takeaways? The software related inventions are patentable only if the software related inventions are patentable only if they show real world technical improvement. That means basically you have to showcase there is some real world problem that is already there. You have made some invention in software domain. You are combining the software and hardware to solve the real world problem, and you are showcasing some technical advancement over the prior documents. If you showcase all these things by claiming the software along with the hardware, you are eligible to get the patent. So the patent will be granted. Okay, so this technical effect plus the hardware integration is very much essential. So you should have some hardware integration, as well as you have to showcase the technical effect. Pure algorithmic or software program per se, that remained excluded under section 3K. Now moving to the next is yeah. So this is the
Sir, I have a
last.
question. Sir, I have one question.
Yes, please proceed.
Yeah, this In the previous slide, this hardware integration is mandatory.
Yes.
For example, if I can bring technical advancement with memory efficiency or executive efficiency for a program, is that patentable, or
Yes, sir.
do I need to use hardware integration?
See, sir, the thing is that a software alone cannot execute it, right? It requires the processor to execute the software, right?
Okay.
So if we claim that these software things are getting executed by the processor, which is basically a hardware, to improve the memory things, then you are eligible to get the patent.
For example, I write one application where I can improve the memory efficiency,
Yes.
and that method I wanted to file the patent. So I am not claiming any hardware, because that application can run in different ways. So
Yes.
now, is that patentable?
Yes. That is patentable. See, nowadays basically we are filing many method things, but what we include that like suppose there is some process, okay? So we just write performing something by the at least one processing unit. So when you are writing that by at least one processing unit, that means that software processing is executed by some hardware. By that way, we generally overcome the objection of this section 3K. We have to mention that memory as well as the computer processor. So that is the mandatory thing. So if we include that processor, because a software alone cannot run, right? A computer program per se. So for that reason, if we include that the processor or like that processing unit, yes, you are able to get the patent on that one.
So if I write one application which can run in different ways and which can run in different missions, which hardware I need to mention? And which can bring a technical advancement, and which can also bring some memory efficiency or execution efficiency, which is not able to handle by previous application. So what is the hardware I gonna mention?
See, basically this type of computer related invention, we generally claim that these are being executed by any processing unit, and by that way basically we generally able to overcome, because we are getting nowadays like various grants on this type of patent application by simply showcasing that are getting executed by the processor, and it is providing some technical advancement.
Okay, thank you. And one more thing, like in the chat I mentioned, is a technical solution you are mentioning, right? What is this technical solution and normal solution? I'm not able to understand, sir.
No, technical solution and normal solution means, see, the thing is that patent is relating to the technical or scientific matter, correct? So, like we have to showcase whatever solution you are providing, that you are executed by the technical or scientific reasons. It's not like the normal way. Okay, suppose you want to claim like you are mixing like sugar with water, so that is only you are doing manually, so there is no technical input, right? So that is the normal solution. But suppose you have made one device that is automatically stirring that one, so that device is technical in nature, so you can claim that device, so you are providing the technical solution. So by that way, that device you can claim, but the manual processing of stirring you cannot claim. So that's why if you provide some technical solution of a particular problem, you are eligible to get the patent on that technical solution.
For example, as you said, if I mix sugar plus water, and if I can bring, as you said in section 3E, if I am not right, and if I can bring the synergetic effect, so is that technical or non-technical, whether it is patentable or not?
No, see, like when you are mixing all these things, so you have to provide the synergistic the effect. So if you are unable to showcase that one, you will not get the patents. So like, see, the main thing is the technical solution you have to provide, and it has to be that solution should not fall under section 3. Then you are get the patent. Otherwise, you will not get the patent.
Yes, sir. I am not able to understand the word technical. what is this technical and not technical. So how can I, if I come up with some invention, how
So
I
just
will,
give an example. Just give an example.
for example, as you said, some water and sugar, if we can mix it. So imagine I will get a solution which will enhance the synergetic effect. Something like, it is going to reduce my, improve my health. So in that case, that mixture is not patentable.
Yes, that mixture is patentable. So what you have to claim in that mixture, the composition thing. So what are the different composition you are mixing, and what is the percentage of composition you are mixing together to get that one, to achieve the synergistic effect. By that way, you can file the patent application.
Here, what is the non-technical term? I mean, I'm trying to understand what is technical and non-technical.
No. See, suppose, the thing is that, suppose, yes. So for example, suppose you want to claim that I have invented one sing or any tune. Okay. So that is eligible to cure some disease. Okay. So you want to claim that tune. Okay. So that will not a patentable subject matter. Okay, because that is not a like that tune or the song that will come under like copyright. Okay, so you cannot claim that one. So technical means like if you can implement that solution by way of like any like engineering or any like scientific method or process, you are eligible to get the patent, sir. So that is technical. That means like by way of scientific solution, you have to provide. You have to provide by way of scientific solution. So that's why we call it as a technical, sir.
Oh, okay. Okay. Thank you.
Okay, so this is the section 3K, and there is the last section, that is the section 3N. See, this is a mere representation. Again, like there one patent that has been filed by Nippon Steel, and that was rejected by section 3N, citing that a mere representation. But again, the like the court has rejected the court has rejected or set aside this particular patent decision that has been taken by the Controller General, and the key takeaways is section 3N applies only to the pure data representation without technical input. Okay, so the examiner must access all the exclusions thoroughly. Okay, because in this patent application, basically there are some technical contribution, and it is not a mere representation. Okay, so the patent office has not rejected this patent application validly. So these are all about today's session. Like if you have any questions or anything, please feel free to ask.
Thank you, Arunava sir, for an insightful session on patentability. Now let's open the floor for the questions. We'll take a couple of questions from our participants. Also, before we proceed, I would like all the participants to kindly turn on their camera for a brief moment so that we can take a group picture. Additionally, I'll be also sharing the Google form link in the chat box. Make sure that you fill in the Google form so that your attendance and your certificates are marked. Participants can go ahead with their questions if they have any. We can all turn on our camera for a brief moment. We'll be able to take a group picture. If you have any questions, please go ahead with your questions. Otherwise, we'll conclude the session.
I don't have any questions, ma'am.
So like any other persons, like these are the actually basically the two most critical sections in Patents Act. So this says basically about the non-patentability. Okay, so outside of all these things, you are eligible to get the patent. So like if you have any question, please feel free to ask. So that like I'll try my best to like explain or provide some insight on your question.
Sir, good evening.
Yes, yes, sir.
My name is Dr. Jabir Singh from Bangalore.
Yes, sir. Please.
My area of specialization is in management science, MBA.
Okay.
So what are the possibility of filing a patent? Any examples, sir? So our area is more of management sciences, human resource management, operation research, supply chain management, logistics. So what are the scopes, sir, for our area?
Yeah, so what I understood from your area, basically, it's a bit difficult because, as I have already said, right? So there is a section 3K which basically bars patenting of the business method. Okay, so whatever you are saying, basically, that will fall under
Okay.
the business method per se. So, like claiming that subject matter, it be difficult in respect of patenting system. But again, like if you are doing, yes, please. Yes, so that is the thing because see, from like Sir was asking like what is technical in nature, right? So from your perspective, like that is the business related things. Okay, so whatever you are doing, so that will basically come under the business method, not the technical per se. Okay, so that will basically are like most probably that will going to reject by the business method. So under section 3K, sir.
Okay. Thank you.
No problem. Thanks, sir.
Do we have any other questions? Is there any other participant who has something to ask? If not, we can conclude the session. In the chat box, you'll find the Google form, which is mandatory to be filled in order to receive your certificates and also to mark your attendance. Make sure that you fill in the form. Thanks a lot, sir, for the insightful session. I don't think we have any more questions. And also, if you have any questions, you can mail us on our web email address, and we'll be happy to resolve any issues or queries.
Right.
Thanks a lot,
Thank
sir.
you.
Madam,
Thank you.
madam,
Thank you.
kindly, madam, kindly share the PPTs in the group, please. Is it possible?
Okay, I'll
Sharing of
share
the
it.
PPTs is possible?
Yes, sir. Yes,
Hello,
sir.
sir.
I'll
I
share
have,
it.
Yesterday and today. Yes, thank you.
I have one question.
Sir, I think
Yeah.
we have another question.
Yes. Please proceed.
So my name is Sugapriya. Actually, I have completed a computer application, MCA. Is that possible for a person who has completed my domain is computer science? It is possible if I become a patent agent. Is it possible to understand the inventions with regards to the electrical and mechanical? Because I'm facing issues, I don't understand the inventions properly.
Okay.
How to
See,
overcome this? Actually,
yeah.
not
See,
because of yes sir, yes sir.
I understand your question. See, the thing is that obviously it's a bit difficult to understand the core electrical or electronics domain related inventions. So that's why basically this field is very specific. Okay, so we are designed to we are eligible to work on the inventions that had been made by from the computer science domain, as you are from the MCA. Okay, but as we are from the science background, if those there are some simple inventions and you are read that thoroughly, and based on your experience, obviously from the day one you are not going to understand that one, but based on your experience when you work in this field for a longer period of time, So the simple inventions relating to the other domain you can understand, but the core electrical or electronics domain, which is very difficult to understand. Let's suppose in communication domain from the electronics, so that is core domain. Okay, so that is very difficult to understand. So these type of things, they are the person who are from the electronics domain, they should handle all those things. So that would be my suggestion only.
Yeah, okay, sir. Actually, my query is it possible for me to, no, I'm not, I don't have, anyway, I'm not going to do drafting for those, in those domains, but it is possible to do other related like prosecution, other works. Is that possible?
Yes. See,
Like,
before the
yeah.
patent office doesn't restrict you to practice. Okay,
Yeah.
patent office, if you are patent agent, you are eligible to practice before the patent office. But when you are like appearing before the controller of patent, you have to argue with respect to that subject matter. To argue that one, you have to understand the subject matter. You are eligible, but whether you are able to explain the subject matter, that depends on your capability, right? So whether you understand it or not. So if you understand, you are eligible to appear before the controller and you made argument with respect to your invention. So no one will going to stop you, but that depends on your capability, whether you will be able to understand and you are able to like argue before the controller of patent.
Yeah, okay, sir. Thank you.
Okay, thank you.
Do we have any more questions? I don't think we have any more questions. Thank you, Maity sir, for sharing your valuable insights on patents. Thank you all the participants for your active engagement. This concludes our today's session. Have a great day ahead.
Okay, thank you so
Thank
much
you,
for
sir.
joining.
Thank you very much.
Thank you very
Thank you,
much. Have a
madam.
good day.
Thank you, sir.
Bye.
Thank you.
Bye.
I would request all the participants to please make sure that you have filled the Google form before you leave the session.
So I am leaving, Bandhav. It is
Yes,
fine,
sir.
right?
Thank
Sure,
you, sir.
ma'am.
Okay.
Yeah.
Thank you.
Sure, sir. Thank you, sir.
Okay, bye. Have a good day. Bye.